So, we have some important news in the battle to end the NFA's restrictions on suppressors. The recent ruling by the Fifth Circuit protecting the NFA's restrictions is now heading for re-ray. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe to the channel. Also, double-check to make sure YouTube is not unsubscribed you. They love to do that, especially on Second Amendment channels. And also, I want to thank one of the main supporters and sponsors of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always expanding upon their benefits. One of the new benefits that you have as a member is that if you find yourself in a self-defense incident and you have a case and you're an AO member, they will guarantee that they will give you 4 attorneys for your case, and that is something that no other company can guarantee. But with AO, you will get 4 self-defense attorneys for your case. So, if you're interested, I highly recommend that you sign up this year to lock in your price. You can do that using the links down below. And if you use my code ARMKOHLER, you can get $50 off of an individual plan and $25 off of a family plan. But those codes are only going to be good for this year. So, again, locking your price this year. As I mentioned in the intro, in this video, we're going to be discussing a suppressor challenge that was recently ruled on by the Fifth Circuit Court of Appeals. This case, U.S. v. Peterson, deals with the constitutionality of the NFA as it applies to suppressors. Mr. D. Peterson challenged his conviction of violating the NFA based on a theory that the NFA and its suppressor restrictions do, in fact, violate the Second Amendment. And on first review of this case, the Fifth Circuit 3-judge panel found that suppressors are not arms, and because of that, they do not trigger 2A protections. However, the Trump DOJ, in their first brief to the Fifth Circuit on Bunk panel, decided to flip their policy, and they stated outright that these type of items cannot be outright banned because suppressors are protected arms. However, I will state at the same time, despite that policy shift, the ATF and the DOJ still argue that the NFA's restrictions do not amount to an outright ban, and therefore it's still consistent with the Second Amendment. So they did say that suppressors are protected arms, but they stated that they could still be restricted. However, now this case is heading back to the Fifth Circuit for on-panel review, and now the Trump DOJ recently submitted their response to that petition, and they continue to argue that the panel should reject this case. And they continue to argue that the NFA's restrictions on suppressors is constitutional because it operates as a shall-issue permit. Now, for those not aware, in this case, essentially back in 2022, both federal and state law enforcement officers executed warrants at Mr. Peterson's home in Louisiana, and he had a home and also a home-based FFL. He was raided by, I believe, 50 law enforcement officers that comprised of ATF agents and local agents, and they executed a search warrant at his home in that home-based FFL. Now, the search warrant was based on some alleged violations of not keeping proper records, some 4473 issues, and then also they said some of the firearms that were sold at that location were eventually also found at some crime scenes. But out of this entire incident, it's the possession of a single solvent trap that led to this challenge. They found a solvent trap in his bedroom safe, and it was not registered under the NFA as a suppressor. And because of that, he was charged with violating the NFA. Now, in response to that charge, Mr. Peterson filed a motion to dismiss the charge based on the Second Amendment. And on review, the district court denied his motion to dismiss. And Mr. Peterson then appealed up to the Fifth Circuit for reversal. And that's when we got the first original review of this case, where the Fifth Circuit sided with the Biden ATF and the Biden DOJ. The Fifth Circuit found that a suppressor is not a necessary curriment of a firearm that is required to make a firearm useful and functional. Mr. Peterson and his counsel filed for a rehearing en banc in the Fifth Circuit. But like I mentioned, that petition was later pulled because the Trump DOJ got control of the case and then shifted policy where they said that suppressors are in fact arms and that they are protected by the Second Amendment. But at the same time, like I mentioned, they said that the NFA could still place restrictions on these protected arms. Now, once that case was mooted and it got back in the hands of the three-judge panel in the Fifth Circuit, that three-judge panel still upheld the NFA's restrictions in that new ruling. The Fifth Circuit still ruled that the NFA can regulate suppressors since the process operates as a shall-issue permit, which they believe is permissible under the Supreme Court's precedent in Bruen. Under Bruen's dicta issued by Justice Kavanaugh, the Supreme Court stated that CCW permit schemes may be generally permissible if they apply objective criteria like background checks, fingerprinting, fees, and other things like that. Here, the Fifth Circuit twisted the Bruen CCW permit ruling and the dicta in that decision to justify the NFA's registration and taxation scheme. That is why this ruling is so concerning. In essence, this Fifth Circuit holding now stands for the proposition that any permit system restricting to a rights may be allowed as long as it operates objectively. However, that ruling is now being challenged, and the en banc panel is being petitioned to review and re-decide this case. In that petition, Mr. Peterson argues that the panel down below mischaracterized how the NFA actually operates. He argues that the panel wrongfully equated the NFA's taxation and registration system for suppressors with something like a shall-issue CCW permit. Now, after that petition, the question really was, how was the Trump administration going to respond to this new petition for Fifth Circuit on panel review? Well, the Trump DOJ continued to argue that the NFA is allowed under the Second Amendment. In that response by the Trump DOJ, they asked for the Fifth Circuit to deny on panel review in this case. And again, they still argue that this is a shallow permit. In that response, the Trump DOJ states that the panel correctly held the NFA's restriction on the possession of unregistered suppressors does not violate the Second Amendment. As the government's earlier filing explained, the NFA imposes only a modest burden on the possession of suppressors. They state that the NFA's restrictions are consistent in both the how and why with historical laws regulating weapons that were particularly susceptible to criminal misuse. Bruen endorsed other similarly modest schemes, such as shall-issue CCW licenses and those types of laws. The panel here acknowledged to shall-issue licensing laws to uphold the NFA's application to Peterson's conduct. Then they also go on to downplay the impact of that ruling by the Fifth Circuit. They state that additionally, the panel's decision would not allow the government to impose taxation and registration requirements on every privately owned firearm in the nation. So that is the horrible ruling that was issued by the three-judge panel in the Fifth Circuit. But now, the Trump DOJ is still asking for the panel to deny review to this case, and they are still arguing in favor of how the NFA operates. They say that it operates as a shall-issue permit scheme, and they claim that that is permissible under Bruen. So this is currently heading for Fifth Circuit on panel review. A petition has been filed. The Trump DOJ has filed their response, and now we're waiting to see how the en banc panel in the Fifth Circuit will now respond to this case. We will now see if this is granted on panel review in the Fifth Circuit. And if it's not, I would anticipate that this would go to the Supreme Court for cert. However, even if that happens, I don't see the Trump DOJ shifting their position. We just saw recently them defend the NFA in a case called Rush and Robinson, which deals with the NFA's restrictions on short-barreled rifles. So, I anticipate they would probably do the same thing in this case if it got in front of the Supreme Court. We're now going to be keeping our eyes on this case to see how this plays out. But again, we see the Trump DOJ continuing to defend the NFA, and they're currently claiming that the NFA and its restrictions on suppressors is simply a shallow permit scheme, and it's just simply a modest burden on the 2A rights of individuals in America and that is permissible under Bruin. So as this develops, as we get more information, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. Also, you can check out one of the 2 videos here on the screen that the YouTube algorithm thinks that you'll find helpful. But as always, thank you all so much for all of your support. And if I forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.